Most Virginia residents assume that if cannabis is legal to possess inside their home, then, well, smoking it there is automatically protected. That assumption feels logical. But in Norfolk, in many condo buildings and HOA-governed communities, that assumption quietly collapses. Because there is a scenario where possession is lawful, and yet enforcement still follows. And earlier I mentioned that something about this changes once a homeowners association gets involved. We'll come back to that, because this is where the legal line shifts. Here's the counterintuitive legal fact. Virginia law allows adults to possess cannabis in private residences. That sounds straightforward. Legally true, yet operationally incomplete. What most residents miss is that Virginia statutes also allow condominium and property owners associations to prohibit smoking inside private units by board vote. So the law says one thing at the state level. But the governing documents may say another. And that's where confusion begins. Let's challenge a belief most of us hold. Many homeowners believe. If it's my property, the state can't tell me I can't smoke inside. That belief makes sense from a personal liberty perspective. But HOA communities are not structured purely around personal autonomy. They are structured around contractual obligations. When you purchase property inside an HOA or condominium regime, you agree, contractually, to abide by covenants, conditions, and restrictions. And contracts do not dissolve simply because state policy evolves. This is where most people stop learning. And where disputes begin. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we're examining why homeowners associations in Norfolk can still ban cannabis smoking inside private residences, even after legalization. We are not discussing promotion, use, or lifestyle. We are examining statutory authority, contract law, nuisance doctrine, and enforcement reality. Because the law says one thing. Enforcement says another. And that distinction matters. Here's the context. Virginia legalized adult possession in 2021. That reform shifted criminal enforcement for simple possession inside private homes. But legalization did not rewrite private contract law. It did not dissolve HOA governance authority. And it did not override nuisance principles embedded in Virginia property law. Condominium and property owners association statutes allow boards, by majority vote, to prohibit smoking within units. Not just in common areas. Inside units. That authority exists independent of cannabis legalization. So when residents hear legal at home, they interpret that as absolute. It isn't absolute inside a contract-governed community. And that distinction often goes unnoticed until enforcement begins. Here's the legal explanation. Under the Virginia Condominium Act and the Virginia Property Owners Association Act, boards may adopt rules to protect health, safety, and quiet enjoyment. Smoking, whether tobacco or cannabis, may be classified as a nuisance. Now, nuisance in legal terms does not mean annoyance. It means substantial interference with another resident's use and enjoyment of their property. Smoke migration through shared ventilation. Odor seeping through walls. Lingering combustion smell in hallways. Those are factors boards rely on. The legalization statute does not prohibit HOAs from regulating smoking. It simply removed certain criminal penalties at the state level. That's a different legal category. Possession legality does not invalidate private covenants. Let me rephrase that. State permission does not erase private contract obligations. And that's where many residents misinterpret their rights. But we haven't yet discussed enforcement mechanics, or what happens when a neighbor files a complaint. We'll get there. How enforcement works. Enforcement does not begin with police. It begins with a complaint. A neighbor smells smoke. They notify property management. Management documents the complaint. The board references its governing documents. If smoking is prohibited, a violation notice is issued. If violations continue, fines may follow. In some cases, litigation. This is not criminal enforcement. It is civil enforcement rooted in contract law. And here's where the distinction becomes critical. The law says one thing. Enforcement says another. State law removed possession penalties. HOA enforcement applies contractual penalties. Entirely different system. And because this is civil, the burden is different. The board does not need laboratory proof of THC concentration. They need evidence of smoking in violation of community rules. Now that may raise another question: what about edibles? We're not resolving that yet. Because the issue becomes more complicated when federal law and medical accommodation arguments enter the picture. Who this affects? Consumers in HOA communities are affected first. They may believe their private residence shields them from restriction. It does not shield them from contract enforcement. Retailers are indirectly affected when customers misunderstand lawful use boundaries. Local governments are affected when residents misattribute HOA enforcement to city policy. And medical cannabis patients face a particularly complex situation. Some argue that smoking cannabis is a reasonable accommodation under the Fair Housing Act. But smoking itself is not a protected class. And cannabis remains illegal federally. So federal illegality complicates accommodation arguments. Not eliminates them. Complicates them. And this is where disputes escalate into formal hearings. But before we resolve the core question, we need to examine why this tension persists even after legalization. Why this matters. Public safety isn't the central issue here. Regulatory clarity is. When residents misunderstand the limits of legalization, conflict follows. Fines accumulate. Legal fees rise. Neighbor relationships deteriorate. Long-term policy implications also emerge. If more associations adopt smoking bans, legalization becomes functionally narrower in dense housing environments. That shapes real-world access. But now we need to return to the unresolved issue introduced earlier. Because this is the turning point. Earlier I mentioned that legalization feels absolute inside a private home, but something changes once an HOA gets involved. This is where that shift becomes clear. Possession is legal. Smoking may not be. And in shared wall communities, enforcement discretion determines the outcome. The law says one thing. Enforcement says another. Residents often believe enforcement would require police involvement. It doesn't. It requires a board vote. That's the inflection point most people never see coming. And now we can walk through how this plays out in practice. Here's a scenario. A Norfolk condo owner legally possesses cannabis. They smoke inside their unit. A neighbor smells smoke through shared ventilation and files a complaint. The board reviews governing documents. Smoking was prohibited by board vote after July 1, 2021. A violation letter is issued. The owner responds. But cannabis is legal in Virginia. That statement is legally accurate. Yet incomplete. The board is not enforcing criminal law. They are enforcing contract law. Fines begin. If unpaid, the association may place a lien. In extreme cases, litigation follows. Now contrast that with a different scenario. The same owner consumes cannabis via edible form. No smoke. No odor migration. No combustion. No nuisance complaint. Enforcement likely never begins. Same substance. Different method. Different outcome. That small legal distinction changes everything. Earlier, the silent question forming was whether legalization protects in-home smoking inside HOA communities. Now the answer becomes clear. Legalization protects possession. It does not override private contractual smoking bans. And that resolution depends entirely on governance structure, not criminal statute. Here's what to watch next. If HOAs can restrict smoking, what happens when a board overreaches? Can homeowners repeal a smoking ban? Virginia law allows members to call a special meeting to vote on rule changes. That opens a different legal pathway. And that may be where the next legal conflict emerges. Here's a question to think about. If legalization expands at the state level, but private governance narrows practical use, has the legal landscape truly changed? Or has enforcement simply shifted forms? Share your perspective respectfully in the comments. If there is a Virginia cannabis law question you want analyzed next, let me know. Like, subscribe, and join the Norfolk City cannabis community for deeper discussion grounded in law, not assumption. Because clarity matters. And in Virginia cannabis law, the law says one thing. Enforcement says another.